Welcome to the Dirty Verdict Podcast, where your host, trial lawyer Kyle Herbert and mediator Peter Taaffe break down Texas legal news, lawsuits, and verdicts. And now, here's Kyle and Peter.
All right, welcome back to another episode of the Dirty Verdict Podcast with Peter Taaffe and Kyle Herbert. Kyle, who do we got with us today?
Oh, Pete, it is so good to be back. Today, we are welcoming two distinguished guests, Kier McAlpine of the Daspit Law Firm, the Right Honorable Kier McAlpine, and Maureen Farrell of Murray and Farrell. Thank you, both of our guests, for joining us today. Great to have you.
Great to be here.
Thanks for inviting us.
Our pleasure. I think we're going to start with grilling Kier. Is that the plan?
Go for it.
Kier, we got a rule here. You can explain the background behind your name, or you can refuse to do that, but we get to make fun of it the whole time. What do you choose?
I choose explaining it, but I still guess you're probably going to be making fun of it the whole time anyway once I tell you what it is. Kier is short for Kiernan. It's Kiernan Angus McAlpine is the name.
Oh, your parents, do you hate them or do they hate you?
It depends.
Neither.
If he's in England, he loves them.
Yeah, that's true.
That's a good Scottish name.
One of my partners keeps busting on me for not going by Angus. He's like, they just gave you this gift. You could be Angus, man. And he just picks up the phone and is like, Angus. And I'm like,
I mean, you might be Angus for the duration of the podcast.
I think it's a pretty damn good name.
Is your family Scottish or English, or do they just like the name?
Yeah, my dad's ethnically Scottish 100%. I've done my sister did the 23andMe, so I know from her that I'm like 76% Scottish. So there it is.
Well, you're right. It's a fantastic name. Thank you for the explanation, and we will almost certainly make fun of it, Angus.
Excellent.
All right, Angus, tell us a little bit about your background. Where are you from? How'd you get here? What are you doing?
I am from Houston, Texas. I grew up here. I went to Bel Air as a magnet student. I participated all 4 years in the Bel Air High School policy debate team, was one of the top competitors in the country at that activity. Went to Middlebury College in Vermont, where I studied philosophy, and I went to University of Texas Law School, and I graduated in 2008. And anybody that's an old millennial like me who graduated from school around that time knows that it was a little bit difficult to find work. So what I did was I started my own firm, Kier McAlpine, attorney at law, PC, around 2010, right after I got my bar results. I took the Texas bar in 2009, and I passed, and I just started up a firm. I had no money, I had no experience, and I had no idea what I was doing, so I just did whatever work that I could find, whether it was e-discovery, contract work. At one point in 2010, I was doing door-to-door sales for AT&T Uverse for a couple of months.
Wow.
And I also did SAT tutoring at one point in 2012 for a couple of months just to supplement the amount of money that I was able to make. But, I went into law school knowing that I wanted to be a trial lawyer. My dad was a big law lawyer for 43 years, and so I knew that I didn't want to do that. And, found myself without a job, so I started my own firm. But then I eventually sort of started doing personal injury around 10 years ago in 2013. And I did defense for maybe 2 to 3 months before irreconcilable differences were discovered. And
did you find you weren't able to fall back on your philosophy major to enter a crackling, sizzling job market?
Almost by definition, that's true. I got a job offer, though, in investment banking in 2009. And I just kind of decided that I was like, I kind of want to stay the course. It would have been a pretty big course correction to go in that other direction. So I was able to finagle a decent job offer, but I decided that suffering for a couple more years before I found my footing in the legal profession was the way to go.
And you found defense work completely anathema to your existence.
Yeah, it was totally anathema to my existence. I can't really get into the exact details of it, but it did not take very long at all before it was just discovered that I had no aptitude for it. And I mean, at that point, I knew I wanted to do plaintiff's work. I knew I wanted to do trial work. But, in that situation that I was in, that a lot of people were in around that time in one way, shape, or form, you have to pay the bills. You got to get some money, and you got to get experience when you're a young lawyer. That's the most important thing. If you're a young lawyer, experience is worth more than money. I tell people this relatively frequently. I didn't take a deposition for 5 years.
Wow.
And lawyers who are starting out with my firm now, where I'm at, Daspit Law Firm, been there for about 9 years. They might be doing multiple depositions within the first couple of months. So So definitely got off to a rocky start, but I don't have exactly the kind of career trajectory that people in law tend to celebrate. We tend to look at these people who have got these like pristine resumes from the beginning to the end. My career started off, I was more, I guess, Jack Sparrow than Jack Bauer in terms of, how I got here. But I'm here and I've got a couple things to brag about. So,
Well, that philosophy study must have certainly prepared you for a difficult legal job market. I think what they say is we can't all be can't.
yeah, it's true. And I mean, like, honestly, if you asked me when I was in my late 20s, like what I would all do differently, like I probably would have been like, well, gee whiz, like I would have done so many things differently. But, where I'm at now, I'm good with it.
You love
I've
it.
made my peace with it. Oh yeah, I love it.
What kind of cases are you handling at Daspit Law Firm?
So 99.9% personal injury. I do have one or two defense cases, but they're all pro bono, people that I know, where I'm not charging them any money to represent them. And do personal injury cases. We have car wreck cases, premises liability cases, tractor trailer cases. We're about to start a 4-week trial, or 4+ week trial, middle of this month, in a plant explosion MDL case where we represent 27 people. So we have a variety of different cases.
Which one is that?
The Carrare, Enrique Carrare, 2018, May 19, 2018, there was a ignition and fire that led to a massive fireball, and there were quite a few claimants, some of which we represent. So we got a first trial group going later this month.
And is it all your clients in the first trial group, or are you with some other lawyers?
It's all our clients. We have some lawyers that are working with us, Randy Sorrells and Dana Kirk. So
What court is that in?
it's in the 234th Judge Reader.
Fantastic judge. I'm sure you're going to get a great trial.
Couldn't ask for a better judge. Yep.
Before we move off of Kiernan's background, you guys have any other brain busters or questions for our blossoming philosopher?
No, I just say I think your background and lead up to where you are now is pretty cool. There we go.
I mean, it took a lot of irrational self-confidence and belief in myself to like keep going down the same road for such a long time. So,
I want to know whether you preferred selling AT&T Uverse door-to-door or tutoring high school students for the SAT.
honestly, I would say that I like doing the door-to-door sales a little bit better.
Interesting.
Yeah, because door-to-door sales is actually pretty good experience. Like that's a hard job.
Yeah.
Like that's a brutal job. You're going to make 50 attempts over the course of 2 days in a particular area. If you score, you're going to get like one sale, and it's going to be completely luck. But I mean, the stuff that you learn, like basic sales tactics, like honestly, give me lawyers that are first-year lawyers in the jobs that we hire for. If you've got sales experience, like you're going to do a lot better than somebody that doesn't. That's just a sheer philosophy major, right? So I definitely like made up for some lost time, learned some just basic communication skills that.
You and I have things in common because I was also a philosophy major and did policy debate in high school.
There it is. Wow.
Yeah.
What a coincidence.
Amazing.
Quinky dink.
I have all sorts of philosophy questions to ask you too, but we may save those till the end
That could be another podcast.
because Pete and I have some. The audience doesn't know this, but when we're not practicing law or doing this, we really ponder the imponderables.
we philosophize.
We philosophize. Mm-hmm. It's deep.
It's like a Parisian salon.
Yeah. No. No.
Yeah, this is a salon.
Yeah.
Yeah.
Exactly.
We pronounce it salon. I don't speak French. I barely speak English. All right. Kier, we invited you on because you've had some recent success in a very case that's very typical to ones that we try all the time. And we heard that you did a fantastic job. And so lay it out for us. You got this verdict a week or two ago. Start out with just a little bit of background. What's the case about? Who did you represent? And give us kind of a good wind up for this case.
Sure, absolutely. So this is a case where the defendant was insured by State Farm. The story of what happened was you had a young lady driving a pickup truck who was looking at her GPS in her car. She had it on where the GPS would dictate directions to her to navigate, but she's looking at the phone out of habit apparently. And so she approaches an intersection, isn't paying attention to the intersection. There's a red light. She blows through the red light and she collides with a gold Impala. All right, so that gold Impala is not occupied by my clients. I don't know who's in that vehicle, but the pickup truck doesn't stop there. So what happens from that point is The pickup truck that the defendant is driving starts to go to her left towards one of those triangular concrete islands, because my clients were in a U-turn lane right there, and they see this vehicle that just got smashed careening towards them, and they try to go in reverse, and then they realize there's somebody behind them and they can't go in reverse. So they see this pickup truck coming at them, and they literally see this lady operating her cell phone. Like, one of my clients, like it's a couple. The woman had actually seen this lady operating her phone, and they see her pop the curb, strike their vehicle from the front, spinning their vehicle 180 degrees around to where the van that my clients are in strikes the other side of the concrete, the other curb. And that's not even enough to stop the pickup. The pickup keeps going until it strikes a concrete barrier beneath the underpass, and that stops her. Okay. So, and this is a part of a docket that we have against that firm, who they have a bunch of cases. They're all with State Farm. None of them are going to settle. They're all extreme low balls or like no offer cases. So what happened last year is I reassigned all those cases to me from the entire firm. Like, if anybody has a case against that particular lawyer at that particular firm that's from the State Farm docket, I am now the lawyer on the case. So this is just one of those cases. And I hadn't worked at the case. I wasn't in the depositions or anything like that. But, the case is going to trial, so I'm going to try the case. And so that's sort of like the liability facts. What was interesting and different about this case, it was the biggest problem for us in trying it, was that, my clients were amazing. Like, they were extremely credible, extremely relatable, extremely likable people. And we all know, like, that makes a huge difference, right? Particularly when you're asking for a lot of money for non-economic damages, because, like it or not, somebody who's relatable is going to have better intangibles for a jury, right? So super likable clients. But what my clients did, though, was they went to their PCP following the incident, all right? And their PCP was one of those PCPs that just doesn't treat car wreck cases. I think we've all encountered that at least once or twice, where somebody's trying to get care through a primary care doctor, and their primary care doctor won't pay attention to them because they don't want to get involved in all the documentation and all the extra work that they can't get paid for in a lawsuit. So they basically don't treat for about 18 months before.
Did they try to go to their doctor and they said, we don't treat people that are in?
Yeah, and I left out an important part of the story where they went to the hospital on the day of. Like, she gets transported on a backboard with a neck collar. He gets diagnosed with a concussion by the ER. She has a broken foot. We have a bunch of photographs of the broken foot. So we've got a really great presentation on day one, but then they go to the PCP and then it falls off a cliff for 18 months.
Did the PCP and backing up, how old are your two clients and how are they related?
60 at the time. So the case was from 2016, so it was an older case. So they aged some since the incident happened. But he was 60 at the time, and she was, I think, 55. Okay. So,
but they had pretty serious injuries, out of the gate.
Yeah. She had. He had the concussion. She had the broken foot. We had a whole bunch of photographs of the broken foot. Another thing that was really nice for the case was that she had a photograph of some pretty bad contusions on her chest from the seatbelt. So they had this amazing initial presentation, really good property damage, but then they have this 18-month gap. So they eventually lawyer up, they get additional treatment, and then they get offered on a 5100 policy 20 and 10 to settle it, which we obviously told them not to do that.
It's pretty generous from State Farm.
Well, State Farm isn't necessarily one of the worst offenders, but this whatever unit is fueling this particular docket of cases is about as bad as it gets.
So just to back up, a 5100 policy, meaning the driver of the other car that was looking at her phone or GPS on her phone, she had a policy that would, if there was a single plaintiff or injured person, they would pay up to 50, and if there's two or more, maximum of $100,000.
Correct, 50 per person, 100 per occurrence is the limit that they had insured. So
did the Gold Impala have claims?
So that's interesting. I don't believe so, because it never came up, and they weren't deposed. Nobody sought to depose them. We just had photographs of the vehicle,
which is pretty cool.
Yeah. So they're, but they weren't even offering anywhere close to the full amount of the policy. So I obviously have the case that's been with our firm for three years at the time or so, and it's going to go to trial. And so clearly the offers communicated again that they'll pay $30,000. Heck no. So we go to trial. And what unfolded was pretty interesting about it. So I've tried 5 cases against this lawyer, like, without naming any names in particular. Like, he's one of these guys where there's a couple of them in town where he's just one of these like heavily frequent flyers on the like private auto insurance defense docket, right? Where there's Mike Cooper, Bill Jackson, Shane Osborne. Like there's like multiple of these guys. And, they're not all the same. I mean, they obviously try cases very differently, but it's somebody who's tried like a lot of cases, maybe 200 or 300 cases. Okay. And comparable age to me. So
that is, I mean, for people that don't know, that is a colossal amount of courtroom work for someone that's been practicing 10 or 20 years.
Yeah, totally. And I mean, I've tried 25 jury cases, and I've got some arbitrations, which, I mean, for somebody that's my age is like supposed to be a lot, right? Certainly enough to get board certified, but we're talking about somebody who's like tried like a ton of cases, ton of car wreck cases. So, it's always interesting to see what they come up with. But, they're in trial every week. So, I go in knowing what kind of caliber of attention that they're going to be paying to the case. And, lawyers that do that type of high volume, private auto case, defense docket, they typically have similar strengths and weaknesses. But this trial was a little bit interesting because the first thing of note that happens when I show up on the day of trial is defense counsel shows up and he's like, we stipulate. And I mean, I determined from reading the depositions and my review of the police report and my client's depositions, like there's not a defense to liability that's any good. But that's never stopped them before.
So you mean they stipulate, just a point of clarification, they're not going to fight you about liability, which means they're saying, it's our fault, we did it, we just want to fight you on damages.
So this gets communicated to me at the beginning in pretrial, and I'm like, yeah, okay. It's like they didn't file a stipulation, they didn't ask me to agree to a stipulation. So, I mean, I go up in voir dire and I, do my whole prepared voir dire that I'm planning to do. And included in that voir dire is one question about, is there anybody here who does not strongly agree with the following statement? A driver that is using their cell phone while operating their vehicle is highly dangerous. Does anybody not strongly agree with that? And nobody raised their hand. So what happened after voir dire was defense counsel was extremely upset because he thought that him saying we stipulate was sufficient to, stave off any mention on my part of any of the liability facts. Okay. And I'm like, well, I didn't mention any liability facts. I just asked them if they thought texting was dangerous. But what ensued was about a 3-hour argument on the record that took most of the afternoon of the first day and some of the morning on the second day about what I should be allowed to say because they were quote unquote stipulating. So the first thing that I did was I said, okay, we don't agree to your stipulation. A stipulation is a contract. You've offered it. I'm declining it. I'm not agreeing to do that. And then there was, a lot of argument, typical arguments from defense counsel where they would say, well, we're not disputing liability, so why are we wasting the court's time on this? It's the exact argument that I'd probably be making if I was them. You want to appeal to the, judicial efficiency and like, why are you wasting time? Stuff like that. Why keep these tax-paying jurors here for longer than they need to be here if we're not arguing about this? And so, those are somewhat...
Had you pled gross?
So that came up later. We had not pled gross. And at one point, what ended up having to happen was they had to move for a trial amendment to file an amended answer that like revoked their general denial and stated, we're only contesting damages. We're not contesting liability. So at that point, because my client, remember I said that, she had seen the person operating the cell phone while the vehicle is like careening towards her. And I remembered at that point that there was part of her deposition where she testified that she'd had like dreams about that. Mm-hmm. So she'd had bad dreams about that image. Yeah. So I'm like, so now this is
part of her non-economic.
This is relevant to mental anguish.
Sure.
So at one point, I was kind of upset that the court was going to grant a trial amendment to allow them to do this because I didn't want them to do it. But then I was sort of like, well, can I have a trial amendment to add gross? Right. But then it didn't come to that because I thought that the court would have to allow this to come in at least somewhat to address, my client's story about how she'd been affected by this. Because if she's having dreams about it and she's testified to that, there it is. So there's mental anguish. There's the cell phone. Because we always want to try our client's best case, right? And I just figured that trying our client's best case in this case meant the jury had to hear not just that the vehicle goes through the red light, because they were fighting me about that. They were trying to keep that out too. They didn't want me to say that she blew through the red light. They just wanted to say, she goes to the intersection and causes a crash. But I wanted the jury to hear the story because I thought that, frankly, when I was discussing it with my clients, not without getting into that too much, like, it was not a popular idea that they wouldn't be allowed to tell a story about what had actually happened to them that had led to all this. So we fought like hell over the course of maybe 3.5 hours to have that, to get to the point where we figured out what I was going to be allowed to say and not say. And it really couldn't have gone any better for us because when I called the defendant as a first witness and I just asked her, okay, your defense lawyer has been saying this whole time, in voir dire in an opening statement that he takes responsibility, that you're taking responsibility. Do you take responsibility for causing this crash? Yes. And then I asked some follow-up questions. I didn't ask her anything about the cell phone because I thought if it's only coming in as part of mental anguish, I'm going to have to just elicit it from that one client during her direct. But then he asked her about what I had said in opening about the cell phone, like, were you texting? No. What were you doing with your cell phone? You're looking at your GPS. And so he basically opens the door to me doing all of the cross about the cell phone that I wanted to do. So that went pretty well for us, I thought, because I just thought it's so much stronger if it's coming out while he's examining her.
Sure.
Kind of like the whole sponsorship strategy deal that I've gotten so fond of recently. And
tell me what you mean by that?
So that's a book that was published in 1990 that's not super well known, but it's called Sponsorship Strategy, and it's you can get used copies of it on Amazon, or at least that's where I got mine. It's not currently on sale by Trial Guides, but it probably should be. But it's some law professors who used to be criminal lawyers who wrote an entire book about, it's a trial practice strategy textbook about how the party that introduces the evidence, which party introduces evidence will affect the jury's perception of it. So it's like pretty common sense that any fact that's elicited that's favorable to the plaintiff's case, that's, elicited from a defense witness on cross is going to carry more weight than what's on direct and stuff like that. And they populate that sort of idea throughout like the entire trial from beginning to end. And they go into all the reasons why it works. It's a pretty awesome book, and it's definitely influenced my thinking a lot. So I'm always looking for ways to have the facts that I want to talk about come out of the other side's witnesses and out of the other side's lawyers. And if there's facts that I don't want to talk about, have the defense bring it up and then have them carry the burden of sponsoring it and have them show the jury that it's relevant because, I'm representing my client. I don't think that those facts are relevant. I don't think that's what the jury should base their decision on. So if they want to talk about it, they have to bring it up. So
is that kind of opposite to the idea of like owning your bad facts and inoculating your jury against your bad facts?
Well, it's not the opposite of it. I mean, it's the exact same principle, which is if something terrible is going to be said about your case, say it yourself.
No, but that's not what he's saying.
It's the opposite of that, but it's this is what's so interesting, right? Because I've read, I've met Keith Mitnick in person. I have a signed copy of Don't Eat the Bruises. So, it's directly from that. But it's like sort of the opposite of that, where it's like you don't want to inoculate necessarily. You only want to inoculate if it's completely unnatural for you to not be the person who brings it up. Because then it will look like you've gone to unreasonable lengths and extra effort to try to avoid presenting the evidence. Okay. So there's a thought process that has to go through, when do you have to own your bad facts and when not? But generally speaking, yeah, it's like the sponsorship strategy idea is that jurors don't trust lawyers to tell them the truth about anything.
That's crazy.
They just trust lawyers to present their client's best case. If the lawyers appear to be competent, then that lawyer can be trusted to put on the best case for that client. So therefore, that lawyer's client's case can be no better than the lawyer is presenting it to be, and it's probably worse. And if that lawyer is sponsoring bad facts about his client's case, it's because he has to. And also it invites the jury to think, well, they're actually probably a little bit better than that because the lawyer's always exaggerating.
So did you bring up the 18-month gap in treatment, or did you?
Yeah, that was the one thing that I had to talk about in opening statement. It was sort of like, I know that there's no way that I cannot tell this story about why they did that because there was all kinds of reasons. The doctor wouldn't let him do it. The doctor didn't want to do it that they had access to. They had a bunch of personal hardships related to their business that was like thrown into turmoil because of loss of the vehicle and loss of physical stuff. So that was, I decided that I had to get in front of that. But, I'm a lot more lately judicious about what do I want to try to inoculate against. So that was interesting. But yeah, I definitely brought that up in the opening statement for sure. But so, I mean, ultimately what happened was, the offer was $30,000 between the two of them. The final judgment, which is agreed, that's already been signed.
Hold on, stop.
Yep.
So how many days did the trial last? 2 days.
2 days.
Who's your judge?
Ursula Hall.
Okay.
Judge Hall.
And so the offer pre-trial, I guess at the same time they were making the stipulation, was they had gone from what, 20 to 30,000 bucks, split it?
It was 20 and 10.
Okay. So they offered 20. What was their original offer?
Man,
you don't remember?
That you're digging deep into the file. At one point, my client Elizabeth Bussell was the one that was offered 20, and Johnny Bessier was the one that was offered 10. At one point, her offer was 12. It went up to 20. I don't, like I said, I parachuted into the case, but so the final offer on it was $30,000 between the two of them, and the jury came back with about $119,000, which with taxable costs and prejudgment interest, the final judgment's like $145,000 or so.
That's not bad.
No, it's not bad.
So I'm looking at it more from a mediator's perspective. So what was their rationale for not tendering the entire policy on a case like this?
So like I said at the very beginning when I started talking about this case is part of a docket of cases from State Farm, like a particular division or unit within State Farm that has been sort of bestowed upon a particular firm. And all of these cases basically have what I'd call the all-state defense, where they're just not offering money and they're going to make the cases go to trial. And there's books that have been written about that. From Good Hands to Boxing Gloves. It's a similar strategy, I assume. So I don't know that there was a whole lot of rationale behind it other than that there were certain doctors affiliated with the case that they didn't want to pay, and they just decided that plaintiffs had to show up in court and get the money from the jury. Mm-hmm. Like I don't think it was that nuanced of a situational risk analysis. I just think they made a high-level decision that we're not going to pay these people, and we're not going to pay that law firm over there, so make them go get the money.
Did you bring any doctors or experts live?
I did. I brought Dr. Oishi. Yeah, we had a doctor.
What do you think, or maybe you asked the jury in particular, what was the thing that they latched onto that pushed? Because a $145,000 verdict on a $30,000 offer is fantastic, and you blew through the policy.
Yeah, and I mean I've had personally really good success trying cases against this particular opponent. I've won 4 of the 5 cases I've tried against him. I asked for $500,000. They said that my clients should get $18,000. The jury gave us $118,000. Okay, so they thought that the gap was too much. They thought that the 18-month meant that the treatment subsequent to that they weren't going to consider, which 18-month gap is a pretty big gap.
Sure, absolutely.
Absolutely. Okay, so there's no question, but the jury believed the severity of the injuries. Like the concussion was real, the broken foot was real, the pain in the neck and the back and all of that. Like my clients did a fantastic job on the stand. And so they awarded, only like $3,000 for one and $15,000 for the other for medical bills. But then, we had
Wait, what were the meds again?
$3,000 for one and then $15,000 for the other. But then we got enough non-economics to take us up to $118,000 combined. So the jury gave pretty considerable consideration for the non-economics, which I think mostly has to do just with the quality of the clients.
What was the type of treatment they had after the gap?
Physical therapy and some injections, and that's it.
I'm always fascinated how lawyers make this tactical decision. How did you argue physical pain, mental anguish in direct and in not argue it? How did you present it in direct, and how did you argue it in closing to help the jury arrive at a number that helped your client out?
So that's a really complicated question that has a really long answer if I come at it generally. What I did in this case in particular was my clients just had a lot of facts about what they did to try to deal with their symptoms. Like during that gap, one of them had like 3 or 4 different medications that he could recite by name that he was taking. He was doing like inversion. He bought something to do inversion therapy at his house. He was hanging upside down. He would do home exercises. So and then stuff that got to me was the guy used to be like Houston rodeo, like cook-off barbecue competitor, where he would do, briskets, and he would do like offsets, which are like you're heaving logs in there every 45 minutes, like kind of an active thing that he just stopped doing since the incident. The woman, Miss Bustle, she had been a golfer since she was 3.5 years old. She was I guess like an Air Force brat, where she was born in Japan. And apparently one of her family members owned a golf course. So she'd just been golfing her whole life. And she's no longer golfing. And I said it in closing statement. I'm like, golfing is one of those sports where you can do golfing your whole life. My great-grandfather golfed every day until he passed away when he was 92. So it's like one of those things you can do forever. She's not doing that anymore. She's got 20 years, average life expectancy. So, money has to be there to compensate for this like beloved pastime she's been doing her whole life that she could do for the rest of her life that she can't do anymore now. And, there's the concussion and there's the dizziness and sort of, I kind of emphasize the granularity of it because I kind of want, what I always think about with non-economic damages is to be like a horror film producer. Not to be crazy, but here's the thing. Like, we've all read probably in advocacy books that anybody that does plaintiff's work, we've all kind of read that jurors take some skepticism and like take with a grain of salt plaintiff's statements about whatever their pain is, whatever their impairment is, and that you have to shift the focus to the defendant and what the defendant did wrong to try to make the jury take the case seriously. But what I've realized is that, and it kind of harkens back to a movie that I remember seeing, like Jurassic Park when I was 11, and like the T-Rex on the screen, where I remember being scared and like wanting to leave the theater and almost walking out, but then realizing it's just a image of the T-Rex on the screen. It's like, if you can make it visceral for the jury, they'll believe it. Like, because you're not going to, like, the skepticism that we think jurors have towards plaintiff cases, they wouldn't have if they were the eyewitness, or they wouldn't have it if it was them that was having the pain or the impairment, right? Or if it was somebody that they knew. So I'm like trying to conjure up a sense of it being real and for them, because if they start to experience it vicariously, right? Like the photographs, like if I have a really swollen purple potato looking foot, I want the jury to look at it because I want them to feel like, ew, because it starts making it real for them. That's how I always look at it. It's like, I want the jury to experience vicarious discomfort, and there's like a variety of ways to do that.
Has the defendant filed their motion for new trial?
They have signed an agreed judgment for the 100% of the damages.
Why did they do that? I have seen.
Tired.
I try a really clean case, man. I really don't. I really do not, and I'm serious about this. Like, I really don't like pushing the envelope.
I have seen that firm file motions for new trial on matters that they stipulated to.
Oh, and I'm not going to tell you a story. I'll tell you later. No, I know, but they didn't do it here.
Well, I hope you get paid soon. That's really a fantastic verdict.
I've got a couple.
Yeah, fire away.
Did you, on the gap in treatment, did you voir dire the panel on that?
I didn't. And I often do, because I have a story about how I delayed treatment until my wife asked me the 25th time if I wanted to go see a doctor a week later. And I had a broken foot. So it's like lots of people do that. I didn't do that this time. One thing I thought was interesting was there were a couple of the doctors, like I said earlier, the clients weren't getting proper care through the health care they had access to at the time. So we gave them some information about people who they could see after they hired us. And Judge Hall let that in. She said during pretrial, like, she denied my motion limiting on that. She let it in. So I had to do voir dire on that, which I thought was interesting. Because I had to do that completely on the fly. I've never done voir dire on that before. It wasn't part of my outline. I've never practiced it.
How hard did the defendants fight on trying to frame the treatment they got post 18 months as something manufactured and pushed by the plaintiff's law firm?
That's all they ever do in every case. That's the defense. That's it.
How did you did you do anything to inoculate against that, other than, I guess, address it in voir dire?
The facts inoculate against it. Like, and this kind of goes back to my point earlier.
Because the injuries were so serious at the very start.
Or just that there's objective evidence of it. Like, if the lady's foot is swollen like a purple baked potato, and there's 15 photos of it in evidence, and there's a photograph of like contusions on her chest from the seatbelt pulling it back, like, they're not gonna doubt that she got injured, and she's transported on a backboard with a neck brace. He has a concussion from the ER. He hits his head against the handle on the side of their van. So if it's real to the jury, those kind of canned arguments don't work anymore.
I also think
so.
that
It's just a fight over credibility at the end of the day.
I also have always thought that there are people can relate to people not wanting to get treatment immediately, right? Like I think that I'm going to be okay.
Yep.
I was hoping it was going to work out. I mean, I find that credible when why didn't you go to the doctor for the first week? Well, I was hopped up on adrenaline at first, and then I just didn't want to go.
Sure.
So I'm like you. I started out when I first got into this business 10 years ago thinking that exact same thing, because I don't always run to the doctor immediately. My wife's like that. If our daughter has anything, she's going to run to the doctor, right? So there are people who will always seek treatment immediately ASAP, no matter what. But there's also people that are major avoiders. Lots of people who have blue collar jobs, right? They're just gonna go work hurt, like sports players play hurt. But I mean, defense lawyers keep harping on that issue because it works.
Did you?
Because it does have some effect, and it has to be dealt with.
You started off talking about how the primary care physician didn't want to treat someone who was in an auto accident. Did you talk about those issues either with the actual jury or in voir dire with the panel?
I didn't talk about it in voir dire. I talked about it in opening statement. I thought it needed to be discussed as part of opening statement because that's the client's story. That's what happened to them, And one of the pieces of feedback that we got from the jury after we got the verdict kind of speaks to what I think our kind of natural advantages over defendants, people that do plaintiff work. They didn't have a story. Whatever they were saying wasn't credible. They didn't have an explanation for it. They were just trying to point this record says this, but that record says that. Or they say they were this hurt, but where's the doctor's visit to corroborate it? They're just exploiting all of the kind of things not lining up perfectly like a textbook presentation. But they didn't have a story to explain it, and the plaintiffs were believable. So if you don't have a better story, then you lose. And so, I think a lot of the time, particularly when you have these high volume, frequent flyer defense lawyers where they know where the pressure points are and they know some tried and true tricks to put pressure on those pressure points, but they don't know how to tell a story because they haven't spent enough time with the file and they don't care either. Yeah. Right? They don't care about whether their client, gets hit or not because it's the insurance company's money. And
to be fair, when you have 3 trial settings every single week, I don't think you're not disparaging the defense bar. It's an industry-wide standard which says you will be set for trial, 6 trial settings for every 2 weeks, and it's impossible for a lawyer, good, bad, or indifferent, to care about a file when you have that volume.
Yeah, if you're one of these high volume lawyer, if you tried a dozen cases in 2020, you're trying a lot of defense cases.
Sure.
And if you're one of those, you're absolutely right. You're not learning the story of the human side of a case. If you got 3 settings in a week,
sure,
you're not doing that.
Okay, I got a quick question.
Yep.
You kind of referenced this about the fight during voir dire, about limiting your questioning or the attempt to. So So I watch trials online when I have a break, and then I'll look and try to figure out what case it is by searching the clerk site, and then in the course of doing that, I'll usually see what's all been filed in the pre-trial. I'm trying to figure out what's going on in the case. What I've noticed a lot is the defendants are filing motions in limine about to asking the court to prohibit plaintiffs from using quote unquote reptile type questioning, and then there's a big pushback from the plaintiffs. I've seen that in the last. I feel like the last 10 that I've dug into.
Really?
Did that come up in your case or in other recent cases, and kind of give us the overview on what that's all about?
So I definitely know what you're talking about. My thinking in trial advocacy is influenced by the reptile, but I don't consider myself in any way to be a reptile practitioner. The last reptile motion in limine that I've seen filed against me was in 2017. But I do know that if somebody was going to file a motion like that, I would know how to respond to it, because those motions limine are always incredibly vague.
Yep.
Like, how do you limine out reptile tactics? That's like, I want to limine out dirtbag defense tactics. What does that even mean?
I had that exact motion filed against me in a rural county, although the defense firm is everyone at this table has had cases against them. And we went down for pretrial, and I said, Judge, so this is a small county that doesn't do a ton of plaintiffs' cases, and the judge had never heard of this reptile concept.
Yeah, a lot of them won't have.
And so I went down there and played dumb. I mean, I know what the reptile is. I know what it is, and I understand the concept.
Did you play dumb or?
That's a really fair question.
That's into my rhetoric. Where that's part of our philosophy.
Let me tell you, I played dumb, but it was exceedingly easy to do.
Compelling.
No, so
I
went in front of the judge and I said, I've read this motion in limine, and if the other side can tell me specifically, because Judge, once you rule in the limine, I'm not going to push the edge. I will do exactly what you tell me, and if he can tell me exactly what I'm allowed to say or not allowed to say, I will abide by it. But I've read a 3-page motion in limine of something about snakes. And I Judge, I'll represent to you. I'm not a T-Rex. I'm not a reptile. I'm not an iguana. I can't lick my eyeballs. I have no idea what he's talking about. And the judge, this poor defense lawyer had filed this boilerplate motion that he pulled off some associate's computer. And the judge said, well, Mr. Defense Lawyer, what is it that Mr. Herbert ought to refrain from? And he said, well, doing reptile stuff. Dude, I
know exactly what you mean.
Doing sneaky reptile things.
You couldn't have played that hand better, because that's exactly it.
Yeah.
The closest thing that I've seen to a motion limine about reptile tactics that could possibly work would be ones that say you're not allowed to say safety rules. It's like, okay, but there's safety rules. Like, who's going to limine that? So
do those ever get granted?
I haven't seen it get granted. I know that I'm sure that there's cases where it has been granted, but maybe the lawyers show up with a lot of particular excerpts from depositions. Like, I would think you would need a lot of pin sites just to even acquaint the judge with what are you talking about? Because you might as well file a motion limine on nuclear verdict tactics. Well, okay, can you be more specific, right?
In my case, he was able to specifically say, Judge, he's not allowed to say that the behavior deviates from accepted standards in the community or will impact standards in the community. And I said, Judge, he's reciting to you the colloquial definition of negligence. Am I not allowed to talk about negligence?
Totally. So, and one thing that, they might try, the one part of reptile theory, I have some mixed feelings about it, and we could probably talk about it on another episode or something, but the thing that is part of reptile that I don't really think that you necessarily should be allowed to do is get into a whole lot of, well, couldn't you have hit a 3-year-old walking across the street?
Sure.
Couldn't you have killed somebody? Couldn't you have done so you start trying to amplify, what is it, the tentacles of danger or whatever?
Yeah.
You start trying to amplify the possible harm associated with the breach of care. If I'm the judge, I'm like,
yeah, but how do you limine that out, right? You object to it.
Well, you don't limine it out. Exactly.
Right.
You object to it, I think.
You object to it as it happens. Because defense lawyers do the same thing in the opposite during voir dire when they want to talk about physical pain, mental anguish, right? They're trying to keep, I've seen defense lawyers do this where they're trying to rehabilitate jurors on things like gross negligence. And, I've had a defense lawyer get up once and say, now you would agree with me, though, even though you told Mr. Herbert you could never award mental anguish damages. But what if it was a child hit by an 18-wheeler that burst into flames and caused the baby's face to melt off? And I'm like, Judge, I got to object to that. That has nothing to do with this case. Now the jury expects me to come up with a dead, bleeding infant whose face is melted off like a wax candle. It's the same objection both ways. If you get too far afield, right, you lose the jury, and the judge has lost control of any sense of what should be going on.
Yeah, in policy debate, you'd call it out around impacts, right? You're not allowed to argue that what they potentially the trial is about liability and damages, and the damages are going to be what actually the damages were alleged to have been, not what they could have been in a different case had different people been involved or had different things happen. So I think there's some degree of
It gets you back, philosophically speaking, to wondering, why would a Wookiee be on Endor?
If you get into a standard, if you have a case where it's like a standard of care fight with an expert, like if you're trying to argue with opposing experts about what should the person have done, like what should the rule have been, then I think you might be able to get into, well, what about this scenario that could have happened? Like, then I think you can probably get into it, but I don't know.
We just need to give Kyle, why would a Wookiee be on Endor?
Well, I mean, no South Park fans. The long speech about the lawyer from South Park. He gives a great closing, asking his rhetorical flourish is, "Let me ask you, why would a Wookiee be on Endor?" You know what? We are going to get the audio from
South Park.
From South Park. We're going to get a licensing agreement, and we're going to play that speach about why a Wookiee would be on Endor.
I just thought
I would just do it. You don't need a licensing agreement.
I'm not making this up.
as long as it's 8 seconds, I think we're fine. According to our legal experts here behind the camera.
I got a couple of quick hitters left.
I got a couple too.
Yeah, fire away.
I'll try to be brief.
Okay, so I watched some of your trial. Did you have an associate with you?
Yeah, I did.
Who was that?
Jonathan Webster.
Got it. Okay. And then you mentioned offline a couple other recent verdicts from your firm. I just want to give you a forum to.
Yeah, we got a $6.9 million verdict in Beaumont in November of 2022 on a wrongful death case where our client got one of those electronic message board signs that's portable that they put up on the road. One of those gets blown by inclement weather off I-10 into her vehicle. It wasn't improperly secured. It wasn't behind a barrier. They didn't have ballast on it. They didn't take it off the road. And it blows into my client's vehicle. She's on Hurricane Alley on I-10. And she dies from complications related to a surgery. And what was cool about that case, or what was tragic about that case, was that like our client, who was apparently a saint, really awesome lady, who had 4 heirs, wrongful death heirs. The defense, case defended by Daryl Barger, he did a really good job defending the case. He parachuted in the case 90 days before we tried it, and he did a really good job under those circumstances. They had a 13-page exhibit that was a list of pre-existing conditions, not a 13-page medical record that had pre-existing conditions in it, a 13-page list of pre-existing conditions. And included in that was not cervical disc herniations or cervical radiculopathy, which is what she got operated on for. So we had a really kind of intense fight about liability in that case, and we had a really intense fight about damages in that case, but we got $6.9 million on that case. So that was a pretty cool result for us. And we just got $4 million on a FILA case that I didn't try. I tried the one that we just talked about in Beaumont, but the one that was in Tarrant County on a FILA case was a stipulated liability case where a guy had a couple of, I believe it was like lower extremity surgeries, and he hasn't been able to work.
And FILA is railroad.
Yeah, it's a railroad case. So it's under the railroad law. And that was a 7-day, like basically like a 2-week trial. And
In Fort Worth?
in Fort Worth, yeah.
Which is very railroad friendly.
Yeah, it's not one of the
at least
venues. It's not a venue that's got me salivating or anything, but the jury apparently was great, and the way they defended the case, like there was a DME, like a defense medical expert. I mean, I almost don't even want to call him an expert based on what I'm about to say, but this defense medical opinion witness alleged, based on his documentation during the IME, that he performed 88 different tests in less than an hour, when there was testimony that he was only in there for about 20 minutes.
Did you tape it?
We didn't have it taped, and I've never had any success with that. I know that that's a good fight that people fight, but I don't fight it, and I've never heard of it working. So we didn't have a tape of it, but he admitted to all this, and it was just, and the jury apparently came back at the end saying that this just goes to show that they would have done almost anything they could to screw this guy, to have this guy give that testimony like the defense doctor like he did. So
it was a worker that worked for the railroad suing his employer.
Yeah, he was suing his employer, and they admitted liability. And but I mean, he had like lower extremity injuries that were operated on, but it wasn't like an insanely catastrophic injury. Like he didn't have spine surgery or anything like that. And we were the client's second law firm, at least the second law firm that had represented him. But he got his day in court, and the client was completely vindicated. Because like he and his first law firm, I believe, split based on them telling him that he should take less than 10% of what the jury ultimately awarded. Wow. So
good job.
All right.
Yeah. So those are some recent victories that we're proud of.
Any more from you, Kyle?
Just 3 real quick ones. I don't want to grade the defense works homework. I know that's a difficult thing to do, but I want to real quick from you. What's the one thing you feel like you did the best at in this trial? The thing that you would go back and do different? And then my final question is, when's the rematch? I'm sure you got a bunch of cases stacked up against this law firm. I want to put it on my calendar. I want to publish the undercard. Like, I want to go out there. I want to bring people. I want to go. I want to watch it for the fireworks.
Please do. So what did I do best? So, I mean, the one thing about this defense lawyer is that this guy, like, he hits hard. Like, he is aggressive as heck. One thing I like about, and I'm not answering your question, I'll get to it in a minute, but I love trying cases against him because I get to be the good guy. Like, I've overheard defense counsel telling their client when they think they can't hear me, it's like, that guy over there can be really abrasive. Like, he can be a real jerk, you know?
Angus? They say that about Angus?
Yeah, they said that about Angus. But when I'm in court against this guy, I'm the good guy.
Sure.
No matter what, which is great. But even when I win, you know, it's like I'm always like so angry, like during the closing argument, because of just like, especially in the rebuttal close, I know the jury can see it on my face and they comment on it too, and I'm like, I'm just so mad.
Yeah. It's hard to be cool.
So that is what I would do better. And this is something this is a known quantity. I've even had focus group jurors say this to me. It's like, I need to do better at not having anything on my face when I'm getting angry because of the BS defense counsel saying. I just need to get better at that. I just do.
It's hard to not be indignant.
Well, because like when like there's only so many punches below the belt that I can take before my like pale face starts turning beet red. You know, there's only so many blows I can take below the belt, and I'm gonna get them. What I did best. I don't know. I thought I was good on my feet with arguing about because I really wanted the jury to hear about the cell phone because I knew, like, I thought that it was important to my clients that be part of the story.
That was a clever way to get it in. I didn't think about it until you said, "Well, it's part of her mental anguish."
Well, I wouldn't have thought of it if she hadn't testified to that 2 years before I was looking at the file. So it was there, but to make the connection, I thought that was bright. I mean, I don't know if it made that much of a difference to the jury, but I thought that was a good moment. And my opening statement was really good. I had a PowerPoint for that. So usually when I'm trying cases against these guys, like I will usually have an associate do an opening statement. It didn't work out that way on this case, but because I was doing the opening statement, I did the whole 9 yards, and I thought it was pretty good.
And the rematch.
Yeah.
Rematch will be. I'll have to send you an email, but it's not going to take long. I mean, it's going to be June, May, like soon.
You got a big 4-week trial though coming up.
Yeah, I've got a 4-week trial coming up, but I'm telling you, I've got a docket of 10+ cases with that firm, so it's going to happen.
Nice. Well, hey man, thanks for all the info about this case, Kier.
Absolutely.
Angus McAlpine.
Thanks
so
for
glad to
inviting
have
me.
you. Hope you can hang out and chat a little bit more.
Yeah, I'm not going anywhere. Let's
great.
go.
That was super fantastic. We'll take a quick break. Thanks very much.
Thanks for joining us this week at the Dirty Verdict Podcast. For links to some of the stories discussed today, please visit our website, www.dirtyverdict.com. If you have obtained a recent verdict and want us to discuss it, please email details on the verdict to us. Also, please follow us wherever you get your podcasts.